Hmm. Um, Betty,
Judge,
are you um, are you still waiting for more people?
we're waiting for more or less 30 people, Judge.
Oh,
I think let's give it a few more minutes,
okay.
and
We'll give
then
it. Okay.
because of the tight schedule, I think we must start
Okay.
after 2 minutes.
Yeah, maybe something to do with load shedding.
Can be, it can
Mm.
be.
Betty,
Judge,
you think we should start? Some
we
people are
can
saying they
start.
can't hear anything.
No, no, we can start, sir.
Okay. All right. Those of you who say you couldn't hear anything, you should be able to hear me now. All right. Good morning. Welcome to this webinar on writing opinions. Now, as legal practitioners, whether you're an attorney or an advocate, or in the corporate world, in government, opinion writing is something you must understand and know how to do. It's part of you being an attorney. Now, opinions you provide opinions all the time without really applying your mind to it and knowing it. Clients phone you, or someone from your organization walks into your office and says, "What do you think about this?" And you tender an opinion, and this person walks out. What I want to deal with today is the formal opinion, where you are briefed or instructed by a client to present an opinion on a certain problem. Now, I'm going to deal with this in two parts. Now, the one thing, I don't know if this is good news or bad news. I think from my point of view, it's good news, but many attorneys think it's bad news. It's bad news. And that is, there is no precedent that you can use for an opinion. Every opinion is different. Of course, you can consult other opinions on a similar topic or a similar problem and use it as a reference work. But you cannot, there are no precedents for opinions. You have to write each one from start to finish as a new document. Now, there is no point in me telling you how to write. You know how to write. You know how to draft. I mean, you can write English. You can write plain English. So I'm not going to spend too much time on that. I'm going to spend my time on two things. The first part, I'm going to be talking about you as a lawyer and the skill sets that you need in order to be able to write opinions effectively. That's the first part. The second part is about the opinion itself. How do you write it? How is it laid out? And I'm going to show you what is required of you in the modern world. For instance, the days when opinions were massive documents that ran into hundreds of pages, that's gone. Nobody wants that anymore. So I will show you how to write shorter opinions. Now, the one thing that troubles lawyers in practice, it's not so troublesome if you're a corporate lawyer or in government, but the practitioners, the problem is that your firm may be subject to a billable hours model. In other words, as a practicing lawyer, you bill according to the number of hours you spend on a matter. Now that presents a huge problem with opinions because you cannot spend too much time on an opinion. If you do spend too many hours and you multiply that by your hourly rate, you might come up with a number that your client may not be happy with. But these days, with the Legal Practice Act and its regulations and rules, as well as the Consumer Protection Act, you will be expected as a lawyer to give your clients an estimate of the fee that you will charge, a quotation. Now, if you spend too much time on the opinion, you might find yourself running at a loss because you will actually exceed in billable hours the amount of time that you spend writing the opinion, which means that you or the firm has run at a loss. I will show you how to get an opinion done quickly, because in practice, time means money. It's not like writing an assignment at university. We had weeks and weeks to do this thing, and then you could get an extension. That doesn't happen in practice. You will be given a very short time period to come up with this opinion. And then, remember, you will have other things to do as well. So you need to be super efficient in writing an opinion. I will show you a method that will make you efficient and enable you to get through this a lot better and quicker. And economically, it must make sense to your firm. Now, the first part, I'm going to spend some time on certain aspects which I think are essential requirements or skills. And then we'll go to the actual writing and layout of an opinion and what's expected of you as a lawyer. Now, remember, writing opinions involves two things. It involves writing skills, which in turn involves thinking skills. Now, think about it. Can you write anything without applying your mind to it? The answer is, of course you can if you're using a precedent. So if you use a precedent, what you're doing is that you're copying someone else's work and you're not applying your own mind. You're not thinking. You're a moron. Okay? We don't want to be morons. We want to be lawyers. So I want to show you how you think through a problem, because what you're doing in practice, whether you're in the corporate world or in general practice, doesn't matter. You are expected to use the law to answer a problem. Now, at university, what we studied was academic law, where you research the law in order to find out what the law is or what the law says. In practice, you have to research the law in order to find an answer to a problem that your client has. That is what we call applied law. Now, opinion writing is all about applied law. Now, you cannot practice applied law if you are not applying your mind properly. So let's look at what are the requirements for applied law. The first is the ability to think like a lawyer. Now, look, I'm not trying to insult anyone. I'm not suggesting you can't think, but there's a technique involved in here. I mean, scientists think differently to the way we think as lawyers. Accountants think differently to the way we think as lawyers. Now, let's concentrate on what you need, how you think as a lawyer. Now, before I go on, just let me mention one thing. The skills I'm going to show you now will assist you no matter what you do as a lawyer. It is not something that you need only to write opinions. It is the kind of skills that will help you on a daily basis. So this first part of this program is absolutely vital. I need you to concentrate. A lot of this stuff may not be in your notes, but don't worry about that. You will follow it, and I expect you to apply this in your practice. Writing is about thinking. Okay. If it's not possible to write anything if you are not applying your mind, because nothing comes out. The only possible way you can write without thinking is if you're copying and pasting. Okay. With an opinion, you are faced with a problem. And client wants not merely your opinion, but in the modern world, clients want an opinion because they're looking for an answer, and that answer must be a practical, executable solution. And that's the second part of your opinion. You can formulate a view and say, this is what I think, but that it doesn't stop there. What clients want is for you to give them a solution. In other words, here's my opinion. Now let me give you some recommendations. So when you get instructed to write an opinion, mostly your clients will not say, I want an opinion, but I also want some solutions or recommendations. They don't tell you that. because they expect you to say so. Your opinion doesn't conclude with a conclusion that says, this is what I think. This is what I believe is meant by this piece of legislation. What you are expected as to do is to then say, my recommendations are as follows. Even where you are not asked to recommend anything, you must make your recommendation. Now, here's the thing about opinions. When you come to a conclusion, it has to be a reasoned conclusion. And that's half of your opinion, where you set out your reasons for coming to that conclusion. The conclusion that you provide your client must always, 100% of the time, be supported by the facts and the law. The conclusion must then be followed by a recommendation. Okay. Now, the most important part is the reasoned conclusion. Now, I'll tell you, a very good example of opinions are judgments. Okay, things are not that great at the moment with our courts. There are judges there who write really good judgments. You should read those judgments. They are excellent examples of opinions. In fact, if you didn't know this, in England, the House of Lords, which is the highest court, they don't call their judgments judgments. They call them opinions. They'll say, this is the opinion of Lord Fitzgerald Jones. And that is what a judgment is. So we'll come back to judgments later, but it's just an example. Now, let's talk about cognitive skills. That is your ability to apply your mind. What do you need? What are the skills that you need? You need the ability to gather relevant facts, and I'll deal with this in more detail. There's no opinion where your client's going to come to you and say, look here, we need an opinion on this particular law point only. Now, that's possible, but it doesn't make sense because there has to be a reason why your client needs you to interpret a particular legal point or legislation. It could be a judgment. What is the factual context? Because then it starts making sense. You cannot practice applied law in a vacuum. What makes applied law is that it is always subject to a set of facts. You must have the ability to analyze facts. You must have the ability to understand the issue or the question. It's a serious misdirection if you get that wrong. You could spend days writing an opinion and client will say, but that's not what I want. I'll tell you how you avoid that. The ability to contextualize the legal rule. Now, in plain language, what does it mean? What that means is client gives you a set of facts. Your job, before you write the opinion, is to contextualize the problem. What is this? This is a tax problem. This is a compliance problem. This is a dispute over the interpretation of a contract. Okay, so you put the problem within a legal pigeonhole, so you contextualize it. And the reason we have to do that is because the law is vast. It's enormous. Okay, so you need to know where to start and what to do. The starting point, as far as the law is concerned, is for you to take the facts and then contextualize it within the correct legal pigeonhole. Then you must have the ability to apply the law to the peculiar facts that your client gives you. These abilities, and there are 5 of them, require cognitive skills. You have to use your mind. Okay. Cognitive skills are the core skills your brain uses to think, read, learn, remember, reason, and pay attention. Now, all of these these skills work together. They take in incoming information. Now, as lawyers, we are bombarded with information all the time from our clients, from judgments, from our colleagues. Your brain actually takes in the knowledge and stores it in a bank. So when you are faced with a problem, what you do is the information that you have in your head is accessed by your mind, and you use it as a lawyer. Now, the reason I said this is because when you are presented with a problem, your mind will immediately say, I think I know the answer. That's your brain going into your, you can call it a data bank of information that you have gathered through your life, and it will come up with an answer. That is what we call intuition. Intuitively, you're thinking, that's the answer. Well, the problem we face as lawyers is that intuition doesn't always work. In fact, you shouldn't rely on intuition. What you have to rely on is reason, analysis, which results in a reasoned conclusion. And we're going to deal with that. Now, let's look at some of the bad habits that we have. Now, we all have these bad habits. The whole point of this exercise is for you to recognize those habits, be alive to them, and stop it when you find yourself doing it. The first one is failure to organize your tasks so that you do not effectively concentrate on the task at hand. A bit of an error there. A lawyer in practice needs to be organized. When you write an opinion, you have to be organized. You have to organize all the material that you have. Then you have to apply your mind. Then you apply reasoning. Now you come to a conclusion. You also, if you're in practice, as you know, there are a million things going on around you. You have to organize your day so that you can apply your mind squarely on the opinion. But trust me, you cannot write an opinion and at the same time worry about sheriff's fees and worry about client calls, answer emails, all of that stuff. It's impossible. You have to shut yourself away from what's happening around you and apply your mind only on the task at hand, being your opinion. If you don't do that, you're going to have a problem. The habit of copying and pasting from authorities. Now, you see, technology has made this easy. You've got a law report, bring it up on your screen. Oh, this passage is brilliant. Scroll, copy, paste. Now, that is not on. That's a terrible habit. And there's a good reason for that. When you copy and paste from a judgment, I assure you, you don't really know what you're doing. You think that passage in that judgment is useful and it is something that you want. That's wrong. In fact, just to give you to make my point, if you look at the rules in the SCA and the Constitutional Court for heads of argument, the rules tell you that you are not to copy and paste from authorities. Why? Because it's a complete waste of time. It doesn't assist the judges, and worst of all, it doesn't assist you, And in an opinion, it will certainly not assist your client. Can you imagine copying and pasting from a judgment in your opinion? Now your client has to read this. The client's going to think, oh, but what the hell is this? Okay, I brief you as a lawyer to tell me what this is. Don't copy and paste from a judgment. So what do? Apply your mind. Read the judgment, locate what you want from the judgment, then write down what's in that judgment in your own words and why it is relevant to your problem. So you write it down in your own words. And I'll say more about this later. But this copying and pasting from authorities, just stop it. It's of no use to anyone. And besides, you fail yourself when you copy and paste from authorities. The habit of looking for a precedent is something that becomes ingrained. It happened to me as well. During my articles, or candidature as you call it today, the first thing you learn, and it's so unfortunate, you learn to use precedents. And from day one, you're stuck on precedent. It becomes a habit. It's like an addiction, okay? Try and wean yourself away from it. You know, there are some things you have to use a precedent, like if you're drafting commercial documents, you have to use the precedent because they developed over years and you cannot possibly write them from start to finish. So use the precedent, but you can't do that for things like particulars of claim, pleadings, affidavits, opinions. You can't do that. And then reading judgments without being alive to the facts of your own case. That's another bad habit. You see, when you do research in practice, in other words, applied law, what you don't want to do is read judgments simply by grazing them. You just read and something clicks and you say, that looks useful. I'll copy and paste it, okay? Now, when you read a judgment in practice, you never start reading judgments until you know the facts of your own case or matter. You will be presented with a set of facts by your client. First, digest those facts, understand those facts, then contextualize the law, then look at a judgment. It's in that order. If you don't know the facts, don't bother with reading judgments, because how would you know that the judgment is relevant? And I'll prove it to you. If you go to court and you tell a judge, my lord, my submission is supported by a decision of the Constitutional Court, and you pompously tell the judge what the reference is and so on. And then that judge looks at you and says, listen, what were the facts of that case? Now, why is the judge asking? Simple. If the facts are distinguishable from your facts, then the judge is not bound by that judgment. It's distinguishable, the judge is not bound by it. Likewise, when you make references to a judgment in your opinion, you want that opinion to be, that judgment to be a binding judgment. So when you say in your opinion, you state a legal principle and you refer to a judgment. If that had to be tested in court, the judge must be bound by that judgment. It's the principle of stare decisis. It's part of our common law system. If a judge is not bound by it because you can distinguish it on the facts, well, you wasted your time in presenting the authority. The habit of merely reading cases and textbooks and filing your chosen authorities only to find that you have to read it again. Now, this is a seriously a bad habit. And I'm going to give you a method that will help you out of it. You did this at university. You know where you researched a topic? You went and read textbooks, periodicals, journals, law reports. And as you read, you thought, this is relevant. So you flag it and you keep it, or you copy and paste it in a file. And at the end of your research, what have you got? You've got a whole lot of flagged authorities. And then what? What are you going to do with it? Now you have to write. So you have to read all over again. Now, trust me, when you're in practice, you just do not have the time to do that. I'll give you a solution to it in a moment. Then there's this habit of reading passively. You know, you can read actively and you can read passively, okay? Now, we all read passively as well. We all do it. It's when you read something, whatever it is, can be a textbook, a newspaper article, or whatever. You could read a whole page without knowing what you read. You can get to the end of the page, and if you ask yourself, well, what was this about? And you think, oh heavens, I don't know, but you read it. That's called passive reading. You're just grazing through. What you want is active reading, where you apply your mind to the content. Now, when you write opinions, the main question is, if I'm reading a judgment, remember, you know the facts. Now you're reading the judgment. As you read, when you apply your mind, you are thinking, how relevant is this to my problem? How relevant is it? How does it advance my knowledge? Can it assist me in resolving the problem? If the answer is yes, now that's a good case for you, okay? So if you read passively, two things happen. One, you understand nothing. Two, you might decide that this case looks like it'll be helpful, so you park it somewhere. All you did is you wasted an hour or two because you've gone nowhere. When you want to write your opinion, and there's this case now, you can't remember a damn thing about it. You have to read it again. Then there's a habit of starting work without a thorough knowledge of all the relevant facts. Now, you know, we all did this. Remember when you issued a summons without really knowing what the facts are, because you used a precedent and you sent it out with the sheriff, and your client's very happy that a summons has gone off. But what you wrote in those particulars of claim came out of Ambler or some other precedent. Well, you can't do that anymore. And certainly you cannot do that with an opinion. You must be well versed with the relevant facts. Now, what you need to know in addition to how to draft is what to draft. Okay. Now, the how to draft is the easy part. What to draft is not so easy. Your analytical skills as a lawyer must come through, because now when you write, so what do you write? You present your reasoned conclusion. So it's the reasons that you are writing. And you cannot find those reasons in any precedents, I can assure you. It must come out of your own thinking, your own application of the facts to the relevant law. Your job is to assist the client to resolve the problem. Now, how do you think this through? Now, what I'm going to do now is I'm going to show you step by step the logical thinking that lawyers apply. This is part of drafting skills. If you're not thinking, you are not drafting. What I'm about to introduce you to is this concept of thinking like a lawyer. Okay. You must have heard this among colleagues, you know. you may be gossiping about another colleague, and someone will say, "Oh, he's a good lawyer," or someone will say, "He can think like a lawyer," or "She can think like a lawyer." We know what that means without being able to define it. What it means is this is a person who can listen to a problem, be able to understand the problem, apply um, his analytical mind as a lawyer, and see the issue and resolve the issue. Now, there's a 6-step logical sequence to this, okay? And always apply these 6 steps when you are researching for an opinion or for anything. If you're researching to draft particulars of claim, this is the logic. Step 1, obtain and absorb all the relevant facts. As a practicing lawyer, the facts are the most important, not the law. I always tell lawyers in practice, the law is the easy part, especially with all the technology we have now with electronic law reports and so on. That's quite easy. The difficult part are the facts. And as lawyers, we take it for granted. Client comes and tells you what happened. You think, I know what it is. Okay. And you don't do a thorough analysis of the facts. Step 2, work out what the issue or question is that arises from those facts. Don't make any assumptions. Look at the facts that come from client. It's their problem. They must tell you what the fact is. The legal issue only arises from some event or a transaction or a dispute. You were not there. Client tells you. Your job is to absorb and collect all the relevant facts. And remember, clients don't always give you all the facts. You listen, absorb, and then you ask questions to fill in the gaps. Okay? Do not make assumptions of fact. Step 3, contextualize the problem in relation to the law. In other words, what area of law is applicable? The issue is governed by a rule of law. So there's a problem. How do you resolve the problem? With reference to the law. Those are the rules that govern the resolution of that problem. Step 4, find the applicable law while focusing on the peculiar facts of your case. You never research the law. You never read textbooks. You never read law reports without knowing the facts first. Step 5, now apply the law to the facts of your case. Do the facts satisfy the requirement of the rule? Now, here's the trick. How do you apply the law to your facts? So you read the law, or what we call the rule. The law tells you that in a dispute like the one you have, these are the requirements if you want a certain remedy. Now, as lawyers, when we look at the law, we are looking for a remedy to a problem. The law tells you if these are your material facts and you can prove it, this is the remedy you will get. Now, those material facts are what academics call the elements of the law. What it actually is, it's the material facts that the law recognizes as giving you a claim or a remedy. So you can see that it's not possible to apply the law if you don't have a sound knowledge of the facts. But there's another problem. If you don't have all the facts, you as a lawyer, when you apply the law, you will be misdirected. You'll go off at a tangent, you'll miss a point, and your opinion may be way off the mark. Step 6, look for an answer to the problem. You must reach a conclusion from a complex set of facts and the law. You know, there was a time when opinions were written and the lawyers, the lawyer reads the law and so on, and it's very gray, it's uncertain, and the opinion says, well, this is a possible answer, but it could also be this, and it might be that. So the client doesn't know where he stands with this thing. Well, you will have opinions where you'll end up in a situation like that. I say, you must say, it's a gray area. There are conflicting decisions. But what you're supposed to do is say, on the facts of your case, this is the conclusion. Come to a conclusion and say, here is my recommendation. Okay, that's what clients want. No client wants an opinion that tells him that it is more of a problem than he thought he had without giving him an answer to the problem. That's useless, okay? Your client's not going to pay you for that. You did that at university because, well, that's what we did, academic law. So this 6-step approach or model of legal reasoning provides a structured method of legal reasoning, okay? With experience, you will develop your own models, okay, and methods of solving factual and legal problems. Now, I'm going to recommend that you should read books which involve logic or logical reasoning and thinking. It helps you to develop models of thinking and rationality. Tomorrow, I will give you a list of books that you should read, all locally available, easy to get. I'm not going to give you references that are difficult to find, but Betty, will you remind me tomorrow to give a list of books that I can recommend?
Will do, Judge.
Okay. Now, if you go through the 6 steps, you will see that there is a logical sequence to it. Okay, it starts with the facts. Then it goes to the law, then it goes to application, then it comes to conclusion. Okay. The point I'm making is that you cannot skip any of the steps. As a lawyer, you go through each of the 6 steps in that sequence, okay? You can't jump to step number 4, as you are often tempted to do. Let me show you. If you start with step number 4, where you go look at the law, without knowing your facts, you're already misdirected. It doesn't work. You have to first get the facts, work out the issue, contextualize the law, then find the law that is relevant to your facts, then apply the law, and now come solve the problem, find the answer. Okay. Now, so when a client comes to you for an opinion, something happened that caused a problem. Before you analyze the problem, find out what happened. What that means is, it's what we say we do all the time. We say we take instructions. Instructions doesn't mean you must sue or defend. Instructions here means tell me what the facts are. Show me all the documents that you have. Okay. Now, here's a basic analysis that you need to do. Obtain all the facts. In other words, sit down and listen to client. Lawyers can be bad listeners, I must tell you. We're too keen to rush off and impress the client with our knowledge, and we sort of take over the whole consultation. Just shut your mouth, sit back, and listen to your client, okay? It's the facts that will assist you to resolve the problem. Now test the facts. One of the important things about an opinion that people don't realize is that you are providing an opinion based on fact. But is there any point in providing an opinion on a set of facts that your client will never be able to prove or may amount to a version that is improbable? Okay. There's no point. Your opinion is worthless completely. So test the facts. Are there other facts or the version, the material facts that make up the version is supported by credible evidence and is capable of being proved in court? Now, you must understand that many opinions that you will write is actually the start of litigation. Because after the opinion, if that doesn't solve the problem, then the parties will litigate over it. And your opinion will play a role in that litigation. Now, if you gave an opinion based on a set of rubbish facts, your client is going to say, if you tell your client, listen, you didn't give me enough facts, client will say, hey, why didn't you ask? I could have given you these facts. Always test the client's version. Again, you cannot prove a set of facts or a version. Logic tells you that if the version is implausible or something that is not likely to have happened, you will not persuade a judge to accept it. Now, is there any point in you writing an opinion which will be regarded as a learned piece of work when it's based on rubbish? You can't do that. And nor can you say afterwards, if someone picks on you, that, oh, sorry, those were my instructions. But you're a lawyer. Couldn't you see that's nonsense? Why didn't you ask? Now, let's look at how you go about a factual analysis. I told you the first step is to listen. Only then write down the material facts of your client's version. Now, very often, especially if you're an advocate, it's the attorney who will come to you and say, these are the facts. So you're not getting the facts firsthand, it's coming from the instructing attorney. There's nothing wrong with that if the attorney was thorough and came up with a very comprehensive set of facts, and you can then write your opinion on that. If you are dealing directly with client as an attorney would, and as well as advocates, you have an opportunity to interrogate the version, ask relevant questions, bring out the facts that you want, and then make a note of it. Make a note of all the undisputed facts between the parties. If there's a dispute involving different, or it's a dispute involving competing versions. With opinions, you don't always have competing versions. There'll be one version, and it may be a question of interpretation of a statute or the application of regulatory frameworks. That stuff doesn't involve disputed versions, but very often opinions do involve competing versions. When there are competing versions, Always note the undisputed facts. Why? Because they help you to work out the probabilities. Now, there's logical thinking. There's also critical thinking. What is meant by critical thinking? It's when your client gives you a narrative, a story. You analyze it. You never accept it as it comes. You question it. I know it's your own client and you're a bit sensitive about questioning your own client, but you can do it sensitively and professionally by bringing out facts that will help you to work out what the version is. Now, once you've got the facts, now work out what is the legal issue. There may be an issue of fact, which will be a dispute of fact. There may be an issue of law. It could be a dispute of law, or it may be an interpretation of the law that arise out of a set of facts. There may be more than one issue. Each issue must be identified logically and rationally, and you must deal with them separately. Where there are more than one issue, rank them in order of importance. And there's a very simple reason for that. Because when you answer legal problems, always look for that one issue that will be resolutive of the whole matter. So you don't have to deal with 3 issues in your opinion. Deal with the one issue that will be resolutive of the whole thing. So that is why you rank the issues. It is important for you to understand how each issue arose from the facts you have gathered. Now, I'll tell you why this is so important. Because it enhances your understanding of the issue. I told you already, you can't get this wrong. If you get this wrong, you are heading for trouble between yourself and your client, okay? Can you imagine having to rewrite an opinion because you didn't identify the issues correctly the first time? Now you have to write it the second time. You can't charge for 2 opinions. Your client won't pay you for the first one, so you run at a loss, okay? Now, one of the things that will help you is once you've been through this process of reasoning, for you to write down in your own words what you see is the issue. The next step, talk to client and say, look, from what you tell me, I think this is the issue. Is that how you see it? Or is there another issue that I'm not seeing or I'm not identifying? You have to settle the issue or the question in consultation with client. Now, I would say 6 out of 10 opinions you do, the issue shouldn't give you trouble. You should put your finger on it, and all client will be able to tell you very easily, especially when it comes to questions of interpretation. They'll just put the law in front of you and say, what does that mean? Okay. Your job is to then say, hold on, why do you need to know what this means? What's the factual context? Now you're thinking like a lawyer. Do you see how the analysis works? Okay. Your client must have a common understanding of the issues between you and your client. There must never be a disconnect between your analysis and what the client regards as a problem. Remember, it's their problem. But clients often misdirect themselves before they come to you. And when you write opinions, be careful of one thing. Client will say, here's the problem. But when you analyze it, you will realize actually there's a bigger problem and it's a different one. In that case, you call client in and you say, These facts and my research of the law tell me that you actually have a bigger problem, and here it is. Okay, that's a good lawyer. A bad lawyer would say, that's not what I'm asked. I'm asked to answer this question, and that's it. That's a bad lawyer. Okay, you are wearing blinkers there. When you research, very often you will come up with a problem that your client didn't see and which you didn't see initially. What happens now is that you call client in, and client will say, oh heavens, we didn't see that. We'd like you to give us an opinion on it. Okay. Now, by now, you know the facts that you worked out, you know the facts and you worked out the issue. Now you have to find the law. Begin by establishing the area of law applicable. Contextualize. That's when you contextualize the issue. This issue belongs in tax. This issue belongs in constitution. This issue belongs in administrative law and a review, okay? Your job is to correctly identify and understand the law. Then you have to explain the law before you apply the facts. Now, there's some more reasoning. You got the facts. You found the law, but it's not enough to find the law. Your job is to explain the law within the context of the facts that you have. And you have to explain the law in your own words, not by copying and pasting from a textbook or a law report. You get it from you write, you read the law, you understand the law, you explain it in your own words in plain language. You have to understand the applicable legislation and the leading cases pertaining to the legal problem. Now, just let me deal with one thing. When it comes to looking at the law is vast, as you know, okay? I mean, you see behind me is a complete set of law reports. That's a lot of books, okay? And there's a lot of law in there. You have to keep narrowing. So you start with your facts. That narrows it down to a particular context. And then you narrow that context to the applicable law. So it's like an inverted triangle. Now, in the modern world, 21st century lawyers, there's one thing we do as 21st century lawyers that people like me come from the previous century did. What we used to do is find as many cases as we can, and we cite them all. There's a point, there are 15 judgments on it. So you put 15 references in there. Well, that's wasting time. Do you think your client is even interested? Not at all. I'll tell you what. Prove my point. Go to the SCA and Constitutional Court rules again. In your heads of argument, they tell you if you have to refer to more than one case, then you must have reasons for doing so. And you must explain why you referred to more than one decision. So what's the answer? Simple. We're a common law country. It means that the law is what the courts say is the law. These are what we call the primary sources of law, and there are two. It's legislation and it's case law. Not textbooks, not journals, none of that other stuff. It's the case law. What you want, and please remember this, all you need for your opinion is to reference the latest decision on the subject of the highest court. That's it. If you've got that one case, that's all you need. There may be 15 other decisions, that support it and that's similar and so on. You don't need it. Just refer to that one case. It's all you want. It's all clients want. In fact, when judges deal with appeals or matters in court, they don't want you to give them 20 case references. They want the most recent decision of the highest court. If you've got a constitutional court judgment, recent judgment on the point, that's all you need. For God's sake, do not look at law reports from 1947 or worse, some of the stuff you see on the shelf here pre-1947. No, you start 2022 and then you move backwards until you find the case you've got. But you start now, 2022. Don't go back. So, and you must learn when you dealing with the case law, you find a judgment. You say that is a relevant judgment. It will be of assistance. It is also the most recent judgment on that case. And there isn't a judgment from a higher court. It's what you want. Now, you need, as a lawyer, to check if that particular judgment is still relevant. How do you do that? Easy. Consult the annotations. So you need electronic law reports to do this. It's almost impossible to check the history of a particular judgment without electronic law reports. And I'm not talking about SAFLI. SAFLI is good because it's free, but it has no annotations. So that's the danger. Okay, Jutostat, Butterworth's, all South African law reports. Those are the only two services that have annotations. So go and look there, click on annotations. It will tell you where that case that you think is a good case for you, whether that case was followed, if it is indeed the most recent decision, was it referenced in other decisions, and most importantly, whether or not it was set aside. Important to know that. So, the law, what you want is one thing. The one case, which is the latest decision of the highest court. Now, here's the important part. When you read the law, and when I say read the law, I mean read a judgment. Write a short chapter summarizing the law as stated in that judgment. And you write it in your own words. You do not copy and paste. What's the benefit of that? The real benefit, and you can try it. It works. Read the judgment and you think, right, that's what I need. Now say, I'm going to write a short chapter of what that judgment says is the law. Now, if you start writing and you put the heading, you put the reference and you start writing and then you stop because you're not sure what to write. Immediately what that tells you is that you actually did not understand the judgment. So you go back and read it, then come and write. When you are able to write the point in your own words, it means that you understood the judgment. Now you're being a good lawyer, okay? Until then, you're not a good lawyer. You are grazing and you're copying and pasting. It's of no use to you. You will never be able to come to a reasoned conclusion. And that's the trick. If you write if you write in your own words, a short paragraph, okay, 10 lines of what that case says, you're already applying the reasoning, because remember, you are applying this within the context of the facts of your case. Never forget that, okay? The writing in your own words, is what happens when you're testing your own understanding of the law. Now, applying the law is probably one of the more difficult steps. At university, you learned the legal rules, or you learned the law. And you learned that the law can be broken up into components. We call those the elements. For example, let's take delict, okay? We learned at university that before you can rely on negligence, you have to first show that on the facts there was a duty of care. That then you have to show that the other party owed your client a duty. Then you have to show that there was a breach of that duty. Then you have to deal with causation, that breach was the cause of the loss, okay? That the loss was not too remote when measured against the breach. So you deal with factual causation, you deal with legal causation. So that's basically what the rule tells you. Now you have to apply that to your facts. So what does the lawyer do? The lawyer looks at those elements and now says, can I satisfy that legal requirement with the facts of my case? If the answer is yes, you've got a cause of action, the law supports you, you're on your way. The rule, when you write your opinion, you first state the law in general terms. Now remember, you would have done that when you read the case and you wrote the short paragraph, where you are stating what the law is that comes out of that case. Then you break it up and say, these are the requirements of that law or that rule. Next step, can I satisfy that with the facts of my case? Now that is what is meant by applying the facts to the law. Okay. The strength of your case will depend on how well you can make out each element of the rule based on the facts of your case. So in plain language, take each element and see if you can satisfy them based on the material facts of your case. Now, here's a reminder. You cannot identify the appropriate law if you do not have a thorough knowledge of the facts. Do you see how important the facts are? This is the process that is at the very heart of legal reasoning. Okay. Now you must come to the conclusion. That's the last step. Your conclusion must be supported by the facts. If there's a disconnect between your conclusion, the law, and the facts, it's useless. Your opinion is useless, okay? Your conclusion must be supported by the rule, the legal rule, the law. And I say, the best place to find support for a legal rule is in the most recent decision of the highest court. You need nothing more than that. We're in a common law country, that's all you want. Now, we spoke about critical thinking. So let's look at critical thinking a little differently. Thinking like a lawyer is more than reading text dispassionately and receiving instructions neutrally. Your job, critical thinking, involves analyzing the facts. So when client gives you instructions and you say, well, those are my instructions, off I go. You are not thinking critically. When you say, let me test that version, is that likely to have happened? No, it's not likely. Now you are being critical. And it's an important part of the reasoning that lawyers apply. It is absolutely essential because, as I told you, instructions are one thing. A good lawyer doesn't slavishly follow instructions. That's not on. You are being really stupid if you do that. You will get into trouble. Apply your mind. So, how do you apply your mind to the facts? And I'm going through this quickly because I've dealt with most of it. Now, what this is a convenient checklist for you. What happened? How did this happen? What caused the trouble? What facts suggest an issue? What are the facts that tell you that there's a problem? What are the undisputed facts? Do the undisputed facts support your client's version? And here's a good test. If the undisputed facts that are out there don't support your client, well, you've got a big problem. Now, when you've got the facts, do something that lawyers have to do. Judges do it all the time. We draw inferences from the facts. We don't simply gather facts for the sake of gathering facts. The whole purpose of gathering facts is so that you can draw inferences from those facts. Okay? Are there any adverse inferences to be drawn? In other words, a set of facts will not necessarily come up with inferences that favor your client. You will come up with inferences that don't favor your client. You'll need to discuss this with clients. In fact, that may be your opinion. That may be the opinion, okay? As a dispassionate observer, do I find client's version to be plausible? This is a big failure with many attorneys and advocates. Because it's their own client, it doesn't mean that you must believe everything they tell you. The modern law has moved away from that nonsense, okay? In the past, if we said those were my instructions, you got away with it. But you can't do that anymore. There's nothing wrong with being curious or inquisitive about your client's version, okay? You don't have to tell your client he's a liar. You just have, you say, listen, this is not likely to have happened. Let's see if we can't do something about it. Now, what are the qualities of someone who practices critical thinking? A critical thinker who is someone who is habitually inquisitive. You must have an inquiring mind. You must ask questions about everything. You must be well informed, okay? You must be well versed in the law and life's experiences, okay? How do you become well informed? By reading a lot, and we'll deal with that again later. Trustful of reason, and that's the thing about that for me is the difference between a good lawyer and a bad lawyer. A good lawyer is trustful of reason, of logic. A bad lawyer ignores reason and logic and slavishly follows instructions, okay? You have to be open-minded, flexible. You must be fair-minded in evaluation. In other words, just put the biases aside, okay? You must be honest in facing your own personal biases. You must be prudent in making judgments. Prudence involves logic, reasoning, willing to consider. You must be clear about the issues. In complex matters, you must be organized. I'll show you later how you can organize the problem and then solve it. You must be diligent in seeking relevant information. That's another way of saying, get all the facts. You must be focused in the inquiry. Now, focus is very important with opinions. I'll tell you why. Client gives you an issue or a question. When you're researching the question, you will come across lots of interesting things. And if you're one of those people that has a passion for the law, you could easily go off at a tangent. You'll think, wow, this is interesting, and you just keep reading on, find that it's actually irrelevant to your opinion. Clients, you maybe find something interesting. Clients will not think it's interesting. Just be careful of that. Persist in seeking results which are as precise as the subject of the circumstances permit. Now, I take this a step further. Seek a result that is as precise, but precision is useless unless you can come up with a result that is practically executable by your client. In other words, you come up with a conclusion, but you make recommendations which your client can immediately implement in the business or whatever enterprise your client is involved in. When engaging in critical thinking, these are the things you have to do. There are 5 of them. Always question. Keep assessing. Nine times out of 10, someone will say, let's test that. And they'll set about a hypothetical problem and they'll test the proposition. That's what you do as a lawyer. You keep testing. You don't accept everything. You test it, okay? You test it against the facts. You test it against the law, okay? So when you have thinking skills, these are the things that you want to look for. You must understand the logical connection between ideas. Now, for instance, we tell you, and it's a requirement in our courts, that the facts must be in a chronological sequence. They must not be all over the place. Why? Because if there's a logical connection between the facts, it makes more sense. The narrative is more clear. Can you imagine if a version is put to a judge, which is all over the place? The judge has difficulty in connecting the pieces and making and coming to a logical conclusion about the narrative that was placed before him or her. So there must be a logical connection between the ideas. So you write your opinion. The factual conclusions that you make must have a logical connection one between the other. The same with the law. There must be a legal and logical connection between the cases that you rely on. Identify, construct, and evaluate arguments. What is an argument? And this is important because you will be writing arguments in your opinion as well. It's the process of reasoning. It's when you present a proposition or a legal conclusion, you must be able to support it with must be able to detect inconsistencies and common mistakes in reasoning. One of the things that will come naturally to you is that if you are a good logical thinker, you will make less mistakes. You will learn to solve problems systematically. Now, what does that mean? You know, legal problems are quite unique, okay? They're not like, it's not like you've got a yes or no answer to them. And that's why people come to a lawyer for an opinion, because there isn't a straightforward answer to this thing. So you set out the problem, the big mistake you will make is to try and answer the whole problem in one go. There may be problems which may be a simple statement or proposition of law. One question, you can answer it. But it's not always as easy as that. The question or the issue may be complex. Your job is to approach it systematically. What that means is break the question up into different parts. Identify, go and answer each part separately. Then the answer to the whole question will emerge. Trust me, it works when you do it like that. Okay? It's like mathematics. If you had to solve an equation, the equation is put in front of you. You don't look at it and say, oh, there's the answer. No, you have to break the equation up into various parts, answer each part, and at the end, you'll come up with an answer and you've solved it. Always identify the relevance and importance of ideas. Very important. Relevance is key to an opinion. Why? Because if you don't confine yourself to only the relevant facts and the law, your opinion will become an enormous document and no one will know what's going on. Even you won't know. Confine yourself only to the relevant facts and the relevant law. Otherwise, you will go off at a tangent or you will give your client answers that they don't really need. It may be interesting, but it's useless, okay, to your client. Right, now before we go on to any other skill, I want to take you to what I consider to be the most fundamental skill or technique in writing opinions. It's what I call the method of write as you read. Now, writing opinions involves two sets of analyses. The first is a factual one. You analyze the facts. Secondly, you research and analyze the law. You always start with the fact. Logic tells you that. And then you read the law. Logic also tells you that you only read the law that is relevant to the facts of your matter. Now, let's cast our minds back to university when you were given an assignment to write. Now, at university, you have the luxury of time. You had loads of time to write an assignment. The lecturer gives you an assignment, gives you a date by which you must submit it. And of course, nobody does anything. And 1 week before the assignment is due, you start writing. You think you better write something. And many people will end up begging the lecturer for an extension. Well, you're a practitioner now. You can't get up to nonsense like that. It will cost you money. Well, let's look at what happens when you wrote an assignment. You did all this research, and now you have to write. So what did you do? You started a new page on your computer, blank white screen. So you write the heading of your assignment. Then you write introduction. And then the problem starts. You sit and you look at it. You don't know what to write. So you decide, leave it. I'll deal with it on Friday. So you leave it. Friday comes, you open up that page, and then you see the heading and the word introduction. So you decide, you know what? Let me change the font slightly. And maybe if I move the heading to the center and I change the font on introduction, and then you sit back and you look at it and you admire the new redesigned page, you see? But then comes the problem again. You don't know what to write. You know what's the biggest problem with writing an assignment. The same as writing an opinion. The biggest problem is getting to your first draft. Once you have a first draft, after that it's easy. You just refine it and you've got it. So how do you prevent this nonsense from taking place? Now, I told you, in practice, you can't do that. The time's running out. Your billable hours have passed already. You're running at a loss. So how do you get this right? By using this technique, write as you read. So what do? You get the facts. Open up a page on your computer and summarize the material facts in your own words and save it. It may come to 3 short paragraphs, save it. And then you're now going to research the law. You come across a case. I told you, read the case, understand the law. Now open up a page on your computer, a file, write a short chapter, put in the reference, write a short chapter in your own words, save it. You will keep researching and you will keep writing, short paragraph, save it. At the end of your research of the facts and the law, you would have saved maybe 15 or 20 short paragraphs in your computer. Now what you do, open another page on your computer. The heading this time will be opinion. Now what you do, go to all these short paragraphs you saved, copy and paste from there. Copy and paste them in a logical sequence, in the order in which you want them. So the order, the facts, that won't be difficult. You copy and paste those short chapters. Make sure you number those chapters. Then go to the file where you saved all your chapters on the law. Take that, copy and paste. And guess what? Just like that, you've got your first draft. And I promise you, from there, it's not difficult. So what happens here is that while you're researching the facts and the law, you are already writing the opinion. What you then have to do is read through all the research that you have. Now, what you'll be researching is the facts that you wrote in your own words and the law that you wrote in your own words. You have a sound understanding. Now you can say, let's apply those facts to this law. Can I, using my facts, satisfy the requirements of this law? And now you are beginning to type in or put in your reasoning. Now, if you don't write as you read, you are going to be inefficient, because what happens? You will do the research, but you will be keeping a track of all the references, because there's an important case. So you'll write Smith versus Jones, 2010, volume 3 essay, and you write it down somewhere. Or if you're old-fashioned and you got one of these sets, you'll flag them and put them on the table somewhere. Well, it's a waste of time, because when you finish your research, you'll be faced with a whole lot of references. And now what do? You want to write your opinion. What do you think you will do? And what you will do is that you'll have to read all over again. And you're going to start reading again. You're going to read all over again. So you're going to do all this research for a second time. And again, if you don't write as you read, you're going to end up in a cycle. And you'll just never get this opinion out, or you'll spend too much time with it, and the senior partner is going to kick your butt because you spent 15 hours, but the fee amounts to 10 hours. You're going to get yourself into trouble. Write as you read, okay? Now, I must tell you, I tested this with a number of master's students from the university in Pretoria. And what happened is we got 8 master's students, and we said to them, when you research your dissertation, use the write as you read method. Now, one of the problems that master's students have is that they always run out of time for presenting their dissertation. Not because they were lazy, it's simply because they had the wrong technique. They tried this method, and I promise you, every one of them finished their dissertations long before it was due. That's how effective it is. Now, can you imagine, as a practicing lawyer, where time means money, if you don't use the write as you read method, you are going to get yourself into trouble when you compare billable hours to the fees that you charged. So those of you who are serious about writing opinions, if it's an important facet of your practice, this is the answer. Write as you read. So when you're reading, keep a page open on your computer. When you read what's there, write it down in your own words. Now, I'm going to recommend. Currently, I'm sitting with 2 screens. I sometimes use 3 screens. This business of using a single screen is not efficient, okay? By the time you keep swapping screens on your taskbar, you waste a lot of time. And also, if you're old like me, for instance, you read a judgment on the screen, now you want to write, so you switch to your Word document. So by the time you did that, you forgot what was in the judgment. So now you've got to switch back and read that particular chapter and then switch again to write. Doesn't work, okay? Have twin screens. Put the judgment on one screen and have your Word document on another screen. Read the judgment, understand what it says, and then start typing in your own words. Now, when you do that, very often there may be a detail that you need to look at again. Not a problem. It's staring at you. You will have it on the next screen. So you quickly reference it and you write. Efficient, it works. And the technology is cheap. Monitors are cheap, and the software, most systems come with software that can accommodate multiple screens. So get it. Just get multiple screens, okay? Right. I'm going to conclude this part by simply saying to you, if there's one thing you learn from this course, it's write as you read. It will help you to become super efficient. And you know what's so important to us? You'll make more money. I mean, I know I'm sounding like an Indian now, but you have to make money. Otherwise, you get turfed out of your firm. You go insolvent. So, this is very much part of lawyers' work. And at some time in your career, you will be called upon to write legal opinions. And even if you don't realize it, you're giving opinions all the time. So writing an opinion requires thorough preparation. It involves 2 disciplines, as I told you, fact analysis or fact management and legal research. Now, I don't want to sound like a stuck record, but I'm talking about discipline now. When you are researching the facts and you're researching the law, write as you research. Keep opening write short paragraphs, save it. Another paragraph, save it. Copy and paste from there. That makes sense because you're not copying and pasting other people's work. Time matters. Your client, if you take too much time, you'll run into one of 2 problems. When you apply your billable hours, client will say, what? I'm not paying you so much for this. Or you'll have the other problem where you gave the client a quote, but your billable hours exceeded. That's when your senior partner will say what? Okay. Now, the next part of the skill set, I'm going to be talking to you about writing skills. That's what we're going to go to now. I'm going to give you a comfort break of 10 minutes now, okay? Betty, it's 12:36. What time do we reconvene?
12:45.
12:45. Can we make
Yeah,
it
it's 9 minutes.
12:50? 12:50.
Okay, we can make
Is
it
that okay?
12:50. That's fine.
Right. Okay. Right. Take a break. We'll come back and continue. All right, can we continue, Betty?
We all good, sir?
Okay, right. All right, let's get back to this. I told you we're going to talk quite briefly about writing technique. Uh, it's really an important part of your opinion that you must write well. You must be able to express yourself in writing so that the reader understands you easily. You know, if a reader has to read your opinion, read the paragraph a second time to try and work out what it means, it's not well written, okay? So what I'm saying is, we don't want you to write like a lawyer. Don't write like a lawyer. Do not produce documents or an opinion that is complex and overrun with jargon that only the legal fraternity understands. You know, lawyers are the worst when it comes to jargon. We use words that only we use, okay? Most people writing a document will say, with reference to paragraph 1 above. Lawyers will say, with reference to paragraph 1 herein above stated. It's such nonsense. Okay. Avoid using long sentences, big words, and legal jargon. What you want is plain language drafting. When the modern technique is that good legal writing is plain language writing. Your document must be user-friendly, and I'll show you how we do that. And it must serve the purpose for which it was produced. The purpose is to give your client an answer in a manner in which he can understand it and be able to follow your recommendations. Now, you have to express yourself concisely and coherently. Say what you have to say and no more. The first rule is stick to being relevant. Now, let's get one thing straight. In the 21st century, nobody likes a long opinion. Now, you might think that if you write a long opinion, your client will be very pleased because your client will think that you put in a lot of work, you wrote 60 pages. They don't care. They really don't care. Okay? I've seen what clients do with a long opinion. They open the first page, they see what the issue is, and they say, yeah, that's what we want him to deal with. And then they go whoops, right to the last page and they read the conclusion. You see, long opinions don't work, okay? It's just a waste of time. Now, you must avoid excessively long sentences. Long sentences are really not good. They can be confusing, and I'll tell you what causes it. It's this habit of using the comma. When you write and you think of a new point, then you go comma and you keep writing, and then you want to make a different point and you go comma and you keep writing. You'll avoid long sentences by stopping to use the comma and use the full stop instead, okay? Always use the active rather than the passive voice. We tend to use passive voice because of our multilingual backgrounds. For example, the court held that. That's the active voice. The passive voice, it was held by the court that. You see, it takes longer. The plaintiff brought a claim. A claim was brought by the plaintiff. You see, the passive voice is not good. Use the active voice. Do not use stock phrases and style tics. Lawyers tend to use the word clearly a lot, all the time. Like, it's not clear. Nothing is clear. Everything starts with clearly or obviously, of course. If matters are so obvious, it will never become a legal opinion, a subject of a legal opinion. Avoid cliches generalizations, and jargon. What is jargon? Jargon is words and phrases which are understood only by the fraternity. You have to be in the profession to understand it. Don't use it, okay? Contractions. This is a formal opinion. Say it is instead of it's. Instead of cannot, say cannot. Don't say can't. So informal language, slang, humor. This comes up in this country. Again, because of our backgrounds, our language preferences. English may not be your first language, in which case you have to be careful. Your writing can be simple, easy to understand, without having to be pompous. Now, when you write like a lawyer, you sound pompous. You think you are clever. You think the reader will be impressed. Well, I've got news for you. They're not impressed. They'll think you're an ass. Don't use big words and complex sentence construction. Now, in this country, you have to be very sensitive. You can't use any references or language that can be perceived to be racist, sexist, or gendered language, okay? Try and be as neutral as possible. Okay, now I want to deal with another very important writing technique. And it is something that is very relevant to lawyers. When you write as a lawyer, you practice what we call point first writing, or another way to describe it is context before detail. What does this mean? It means that when you write as a lawyer, you want the reader to accept what you're saying. You don't want the reader to make up their own minds, okay? That's not what a lawyer does. Nor do you want to keep the reader in suspense. That's what people who write thrillers and romantic novels, they do that. We don't do things like that. We are lawyers. You don't keep your client guessing or speculating. What this means is, when you want to make a point, you make the point first, then you give the details. So, for example, you'll say, the company committed a breach of contract. Now you say why. Don't write the details and then at the end say, in the premises, the company committed a breach of contract. So the conclusion or the point is slotting at the end, which is a logical place to put it, okay? It's not illogical, but it's not good legal writing. Legal writing, you state the point up front, then you give the reasons. Now, that has two very important purposes. When you tell the reader what your point is up front, the reader immediately has the point in the reader's head. The reader is not going to be misdirected because when the reader reads the details, the reader knows that the details are heading towards making the point that they've already read. It becomes more memorable because as they read your details and you get to the end of your details, the reader thinks, now I see it. Now I know why there's a breach, okay? But if you didn't plant the point in the reader's head up front, and the reader now reads the details, and then you say, this is a breach, the reader is thinking, well, is it a breach? I don't agree with it. I have a different idea. That's not good. When you write any legal document, you always state your point first. Even when you're writing a letter, you state what why the letter is being written up front. You learned at school, business letters, you always say, "Dear Sir, RE, this is what the letter is about," and you put it in and you underline it, and now the reader understands the context. That is very useful. When you write an opinion, you practice context before detail. Now, let me tell you what is the modern way of setting out an opinion, and I'll deal with this in more detail later. But what you want is this. First, you say what the issue is. Now, don't start setting out your reasoning and so on. You immediately say, this is the issue. Here's my answer. This is my recommendation. Now, let me tell you how I got there. So on page 1, or say between page 1 and 2, you already told the reader, here's the issue, there's my answer, and there's my recommendation. You know what? Your client is hardly likely to read the rest of your opinion. That's the modern way of doing it. Now, if your opinion covered a particularly complex issue, and of necessity, your opinion became long, that's fine. Use the same method, except now, what you also do is at the end of when you finished your opinion, you then write what we call a summary. Some people like calling it an executive summary. If you're writing the opinion for government officials, always call it an executive summary because they like being executives. Or if you've got a very pedantic client, you say executive summary. But if you wrote summary, it's good enough. That must be no more than 3 pages in which you say, this is the issue, here's my conclusion, these are the recommendations. 3 pages. You supply that as a separate document that sits on top of your main opinion. When clients need to use your opinion, say they're in a board meeting or they have to make decisions, they'll take the summary with them. If anyone wants to read the details or the reasoning or the authorities, they will look at the main body of your opinion, okay? So, context before detail. When you write affidavits, you must use this method. We encourage lawyers to use headings before each paragraph. The heading is absolutely useful. It's context before detail. It tells the reader before they even get to the content of your paragraph what the paragraph is about. So the context is in their minds already. So, for example, in an application for sequestration, you're drafting the founding affidavit. Your headings will go like this: the parties, okay, jurisdiction, the debt, the act of insolvency, advantage to creditors, service on the master. You see, each of those paragraphs tell the reader what's in there. And for judges, they need that because they're looking for it and they'll just tick it off. For clients, it makes it easy to read and reference. The heading tells them what's in that paragraph. It's context before detail. Negligently, upfront, in that, and now you give the details. You don't say, on such and such a date, the defendant was driving a vehicle and did the following, A, B, C, and then you say, in conclusion, the conduct amounted to negligent driving. You know what? Your reader might think, is it negligent? Start the sentence by saying, defendant drove the vehicle negligently, and now say why, okay? So it's the same with affidavits, whether it's founding or answering. Start the paragraph with a key sentence. The key sentence is the point that you want to make in that paragraph. Then give the details. That's good legal writing, and that's what you're supposed to do. The length of your sentences must be varied. Use short sentences to emphasize ideas, and use longer sentences to explain, to define or illustrate. Put keywords and ideas at the beginning or end of the sentence. Don't bury them in the middle of a long sentence. Emphasize keywords by placing them at the beginning or at the end. Vary the sentence types and structures. Vary the sentence types by including occasional questions and commands. Vary the structure by blending simple, compound, and complex sentences. You must never have clutter in your opinion. When you revise an opinion, when you write it first, and then when you revise it, eliminate unnecessary words. Eliminate facts that are not necessary or relevant to the issue. Keep it precise and keep it short. What is meant by plain language? Remember, it is a established technique in writing that when you write, whatever you write, you must bear in mind your audience. In other words, who's going to read it? You write your opinion according to who's going to read it. Your client is the CEO of a multinational company. He's going to require a certain standard. You write according to that standard, okay? Your client is a small business. Write according to what that client will expect and be comfortable with. Consider your reader when you write. But I say, no matter who your reader is, stick to plain English, okay? Plain language writing. Now, these are the things you have to do. Write short sentences. Say what you have to say and no more, okay? Use the active voice. Use everyday words. Words that people use daily. Use words consistently. Avoid strings of synonyms. You know, lawyers, this is a lawyer's thing. I'm just trying to think of one or two. To do and perform. It's the same thing, okay? You know, I just can't think of you take the same word, but you have two other words that mean the same thing. It might look impressive, but serves no purpose. Avoid unnecessary formality. In opinion writing, we don't want to go for unnecessary formality. If you're writing heads of argument, you can be a little more formal, but you're addressing your client. You must organize your text into logical sequence. You must have informative headings with a table of contents for long documents. I told you don't write long opinions, but if you have to, include a table of contents. Make the document attractive and designed for easy reading. Now, you will notice that a lot of this, what I suggested, what I'm telling you, is meant to address the bad writing habits of lawyers. Now, just let me go back to making an attractive document. You know, before we entered into the digital era, We used to write opinions, then it was printed, then we bound it, made it look really wonderful, and then delivered it to client. In fact, the bigger firms had a printing room and they had binding facilities in the office. And they had a person there who was skilled at doing these things. And this opinion went off to the client. It looked really. The opinion is delivered electronically. That doesn't mean you don't have to make it look attractive and user-friendly. And I'll tell you how to make it look user-friendly as we go along. But there's an interesting thing here. The institute, the Legal Writing Institute in the United States, which is an institute which is supported by the entire legal profession, they had this to say, and I'm repeating it here because it is so relevant to opinion writing. The way lawyers write has been a source of complaint about lawyers for more than 4 centuries. So you see, we've been causing the trouble for a very long time. The language used by lawyers should agree with common speech, unless there are reasons for a difference. Legalese is unnecessary and no more precise than plain language. For instance, if you want to say, in your opinion, reference will be made in paragraph 8 below. Now, how easy is that? Now, lawyers will say, in paragraph herein below stated. I mean, where else can it be? Why can't you just say below, full stop? Okay. Plain language is an important part of good legal writing. I told you, legal writing, good legal writing is plain language writing. Plain language means language that is clearly and readily understandable to the intended reader. Okay. You see, a reader must be able to understand what you wrote on the first reading. If they have to go back and read it again and again to work out what you said, that's bad. You don't write opinions like that, okay? So I've taken you these guidelines. I've given them to you in your notes. I want you to go and follow them. It's just a nice checklist for plain lawyers. And this was actually produced by the National Consumer Council in London, which is promoting the use of plain language for lawyers. Okay. So plain language involves the use of plain and straightforward language which conveys its meaning as clearly and simply as possible without unnecessary pretension or embellishment. That's the definition that's in Richard Wydick's book, Plain English for Lawyers. A communication is in plain language if the language structure and design are so clear that the intended audience, see the point? Intended audience can easily find what they need, understand what they find, and use that information. Now, that is an opinion. When you write an opinion, that's what you want. You want your client to easily understand it, find what they want, and be able to use it, okay? Now, plain language is directed at the convenience and ease of reference for the reader. The reader never needs to go to the back of a sentence, go back, reread it to understand it. Never needs to stop and examine the sentence to work out what it means. Can always see the next sentence follows on from the one before. You see, that's plain language writing. Because reading is also something that happens in a sequence. Your ideas and thoughts, your next thought must flow from the previous one. And when you write plain language, that becomes easy to follow. They find no words that they do not understand. They grasp what you have said in one reading. And here's the trick. The reader understands at the same speed as they read. That's vitally important, okay? When you write, now lawyers write all the time. These are the things we do. We write to inform people. We express opinions. We record terms of an agreement when we draft a contract. We record terms of a transaction. We make demand. We set out causes of action in a summons. We set out the facts and the law. All of it must be done in plain language. Now, the opinion, your opinion, will depend on the following. This is what, broadly speaking, will be in the opinion. The evidence, in other words, the facts, logical reasoning, application of legal principle. The substance of the message and the style of presentation together determine its persuasiveness, its usefulness, and they go hand in hand. So, the substance of the message and the style in which you present it. The style, plain language, sequential, easy to understand. The substance, logical reasoning. Okay? Lawyers must master the art, technique, and skill of persuasive legal writing. Legal writing is about persuasive writing. Just remember that. You inform, but you want to tell the reader that is the information. You don't need more than that. You present an opinion, you're telling the reader that is what you need to know. You need no more than that. Now, I've been to know your audience. Always write with your audience in mind, okay? Once you know your audience, you can set the style and the tone of your writing. But again, I don't care who your audience is, stick to plain language writing. I've dealt with context before detail, but there's another point being made here. When you practice context before detail, where you tell the reader up front what's coming, it acts as a roadmap to tell the reader what to expect. Now, let's take an opinion that involves a number of complex issues. Issues of fact and law. When you start your opinion, you will do the same thing. You'll say, here's the question. This is my answer. And now let me tell you how I got there. By the way, that method where you tell the reader up front what the answer is or what the conclusion is now the new way of writing judgments. I told you what judges write is actually an opinion, okay? So if those of you who've been reading constitutional court judgments and SCA judgment, you will see that the judgment starts with a brief summary at the top of what the matter is about, and then it has the order. The court order appears right there up front. It says order of court, and it goes 1, 2, 3, or A, B, C. Then comes the judgment itself, the reasons, okay? And you will notice that the courts now, all of the judges, High Court, all the divisions of the High Court, all the way up to Constitutional Court, they use headings and numbered paragraphs in the judgment. If you go and look at older judgments, you will see that they are very dense, difficult to read, no numbering, no paragraph headings, and not user-friendly. Whereas modern judgments are different. Your opinion also has to follow that structure, okay? In any opinion, is you must frame the issues briefly and accurately. When you start your opinion, you have to start by stating the issues between the parties, okay? Then you will tell in your very next paragraph, your conclusion. The third paragraph, your recommendations. And now you go the facts or factual background. Now you deal with the facts. Then you deal with the law. Now you deal with your reasoning. Then there's the conclusion and recommendations. Okay. So the issues up front have to be stated briefly and accurately. You'll expand on them when you come to your full reasons. When you've stated the issue, your task is to state the supporting facts, or the facts as you've been instructed with. The reader must be able to see your point easily. The idea is not to make the reader do the work. You have to do the work. You see, the one way to measure good writing is when the reader can read it, absorb it, and use it effortlessly. If the reader has to struggle through the document, go back and read it again, come back, and then start again, it's not a good document, okay? Always use headings, okay? Like factual background, conclusion, recommendation, factual background, the relevant case law, you see? It's a good idea to write short paragraphs. Try and confine a fact set or a legal point to one paragraph. Don't state more than one fact set or legal point in the same paragraph. Short paragraphs work very well because they allow the reader to assimilate the point you're making. Then there's the gap, and now you go into your next paragraph. And please remember, there must be a logical sequence to your paragraphs. Your next paragraphs flows logically from the previous one, okay? User friendliness, okay. I've told you, these days we don't dress up the opinion in fancy binding, but how you present your opinion in your, when you write the opinion, you must use a user-friendly style. So use a decent font. Don't go more than 14 or less than 10. It must be pleasing to the eye. Use a good font, Calibri, Arial, Century Gothic. Those are the ones that are quite pleasing to the eye, easy to read. Use spacing. It's what we call white space. Use white spacing in your opinion. Your opinion must not come across in a document that looks dense and difficult to read. Those of you who are familiar with the with the Consumer Protection Act, there you will see that business is now obliged to write contracts in a user-friendly format. They're not allowed to use fine print anymore. There has to be decent sized font with spacing, and they are supposed to write in plain language, okay? So Make it look easy to read and attractive to read. Keep it short. The thicker the document, the less persuasive it becomes. I write there, ask any judge, okay? Now, how will you keep it short? By being relevant, concise, and to the point. You don't want to include very interesting things. Just because you think it's fascinating and interesting doesn't mean your client will. In your opinion, avoid repetition, avoid inclusion of factual details that are not necessary to answer the question. Trust me, no one wants a long opinion. Footnotes. It's not good for opinions. If you want to use footnotes, use it only for referencing. Do not make a point in a footnote because it's disruptive. You've got someone reading a paragraph. Now there's a footnote. They have to go and move from that point to the bottom of the page. Sometimes the footnote, if you're a bad writer, the footnote may be on the next page, which is even worse. So it's complete distraction. Now, there's a simple test. If a point is important enough to be included in your opinion, why on earth relegate it to a footnote? Make the point in the body of your opinion in its right place within a paragraph. If it is not that important, why include it at all? What some people do is that they think this is not really a bullet point, so I won't exclude it, I'll put it in a footnote. Who cares? Nobody wants to read it. I mean, we all read books. Textbooks, for example, are replete with footnotes. I'll tell you what happens. As you read, you're looking for a point. You're reading in order to understand the law. You haven't got time to troll through the footnotes, so you just ignore them. And if your lay client gives you wants an opinion, that lay client is going to leave out the footnotes. So don't waste your time. Just leave the footnotes. If you want, just use the footnotes for referencing. When I write opinions, remember, I come from a generation that did not have computers. We wrote our opinions on typewriters. Secretary typed it out. Do you know how difficult it was to type footnotes? So we avoided it. So now I still, in my opinions, in my heads of argument, I put the reference right there where it should be. I'm not putting it in a footnote, okay? Sentence construction is very important. I told you, avoid the long sentences, complex sentences. And Will Rogers was an American. He wrote this. I think it's so appropriate. The minute you read something and you cannot understand it, you can almost be sure that it was drawn by a lawyer. Seriously, that's what we are. The secret is to write sentences where you use few words and is plain to understand only in one way. Now, you know, we're a curious profession. Go and read the law reports on interpretation of contracts. You will see hundreds of cases, reported decisions. The common law is so well developed on how to interpret contracts. So who wrote the contract? The lawyers did. But now the same lawyers don't know what it means. So now they have to go and take it to a judge so the judge can tell them what the contract means. They wrote the contract, but they now need a judge to tell them what it means. Do you see how ridiculous this is? Well, that's what happens with lawyers. And we got a bad name as a result of it. Stick to the plain language, you will avoid the problem. I told you, use active voice. Quotations. I dealt with it already. Everybody hates reading copious quotations from other authorities. No one wants it. By the way, in the SCA rules and in the Constitutional Court, they tell you not to quote from law reports and from the record. They want you to express the point in your own words. You only include a quotation if it was unavoidable. Now, I can tell you there are cases, reported decisions, where the lawyers, including counsel, were disallowed their fees and punished with cost orders for copiously copying and pasting from law reports. No one wants it. Judges hate it. Your clients will hate it even more. Okay. Always, if you read something that you want to include in your opinion, and that happens all the time, read it, understand it, write it in your own words. And here's the trick. If you can't write it in your own words, it means you didn't understand it. And the culprits who copy and paste are usually the ones who don't understand the point. But they're fooling themselves. They think, you know what, if I copy and paste this whole thing, then I'm covered. The reader can see it, okay? And then I've made my point. Rubbish. The reader doesn't want to read it. They'll skip it. What the reader wants is to read your point, as you state it in your own words, okay? Legalese, jargon, just stop it, okay? Look at these things, hereinafter, herein above, herein under, wheresoever, above mentioned, heretofore, forthwith, okay? It's such nonsense. Do you speak like that when you talk to a friend? Do you go to a friend on Monday morning and say, oh, hello, John, as per our conversation of the 5th ultimo, do you speak like that? No. So why do you write like that? Now, let me tell you this. I've got an interest in drafting, as you can see. Where does all this rubbish language come from? Because you never learn this at university. You study English at university. They'll never teach you this nonsense. No law lecturer ever taught you to write like this. You know where this comes from? It comes from old precedents. The minute you enter a law firm, that's when you start learning words like forthwith and whereas and herein above. Okay, heretofore. That's where you see it. And where do you see it? You see it in old precedents. So just stop it. Just throw all those old precedents away. Or in your opinions, you must use numbered paragraphs. Goes without saying, okay? And let's look at some common mistakes. The paragraph contains more than one topic or point. That's bad. The document repeats the same point over several paragraphs. No good. Instead, use subparagraphs if you need to use separate paragraphs for the same point. The paragraph is too long and makes it hard for the reader to digest. A paragraph that runs a whole page or even goes on to the next page, no good. What will improve your technique is that each paragraph, one point, I've dealt with this. Every sentence in that paragraph should relate to that point. So remember, context before detail, state your point up front, and then give the details using plain language, and each sentence is linked to the other, and all of those sentences will support or will explain the point that you made. It is also not a good idea to use a series of very short paragraphs, 1 or 2 sentences. That also doesn't work, because then you get what we call the staccato effect. You know, it's like you're reading 2 lines there and then 2 lines there and another 1 line there. What you're doing is you're going to scatter your point. So don't do that either. a document should flow logically from one paragraph to the next. Now, before I forget this point, when you write an opinion, it is often, in a complex opinion, it is very useful for you to give the reader an idea of how you laid out the opinion. So you start as usual. Here's the issue. Here's my conclusion. These are the recommendations. The next paragraph, the opinion is set out as follows. In part A, I deal with the facts of the case or the factual background. In part B, I set out an analysis of those facts. In part C, there's a discussion of the most recent cases. In part D, I set out an application of the law to the cases. Do you see, what you're doing is you're giving a heads up or a map to the rest of your opinion. That's also a very useful technique to use in motion court when you're writing founding affidavits, answering affidavits. When you've dealt with the formalities, always right up front, you say to the judge, this is how we're going to deal. I set out this affidavit. Split it into parts, and before you write any detail, you put part A, fact, part B, analysis, okay? So that's a very useful thing to do. Judges love it, your clients will love it. The sentencing must be ordered so that they deal with the subject logically, okay? I've dealt with all of this. Now, I want to come to writing the opinion itself. So up to now, I spoke to you about reasoning, logic, techniques, write as you read, context before detail, structures of your sentences, and so on. Those techniques are absolutely essential. It will make your opinion so much more professional and easy to use. So let's get to the opinion itself. So what's the definition of an opinion? What we're dealing with here is a formal opinion, and it is not lay opinion, okay? Lay opinion is when someone shoots their mouths off and expresses an opinion. Like if I say, Kaiser Chiefs will never win a trophy ever again. So what? Who cares? I'm just talking nonsense. It's a lay opinion, okay? A legal opinion is defined as follows. Written statement by a court, judicial official, or legal expert as to the legality or illegality of an action, condition, or intent. This will include questions of interpretation and compliance. Okay, these are formal definitions. Written statement by a lawyer of what he or she believes the legal position to be governing a matter referred to him or her by a client. It is a document by which a lawyer communicates legal advice to a client. Okay? Both those definitions are sound. So what are the types of opinion that you will provide? And you will experience all of these in your practices. A formal written opinion, that you're quite familiar with that. A client wants you to provide a legal opinion. An informal oral opinion an oral opinion. This is where client comes in for a consultation, you sit down and he says, listen, I'm about to enter into a deal. What do you say about this provision in the contract? And you give an opinion. Client says, thank you very much, goes away, you charge a fee. An informal oral opinion in consultation. That's where the client comes in and says, just tell me what this means, or can I do this? and then they go off. Nothing in writing. A memorandum. Now, a memorandum is different to an opinion, because a memorandum is meant to be less formal and is written for purposes of information, okay? And then you have a lawyer's nightmare, the worst nightmare, an urgent opinion. Client calls and says, we are going into a deal tomorrow. Can I have this opinion by 4 o'clock today? That will happen, okay? And I'll show you how you deal with these things as we go along. Now, I start with a word of warning. You'll be approached to give an urgent opinion from time to time. The circumstances may be urgent to your client, and your client wants an opinion. It is usually given orally in a consultation. These days, that can happen on a Teams meeting or a Zoom meeting, on the telephone even, or you can convey an opinion in a memorandum that is delivered within hours of instructions. Where you are called upon to give an urgent opinion, make certain you provide for a disclaimer. That's important for lawyers. Your opinion was based on the available facts, and little or no time was provided for proper research. Now, I say, when you give an oral opinion, it is a very good practice to follow it up with a written memo or a written opinion in which you state your disclaimer. You know, when I was a young attorney, we never sued each other. Seriously, the client came and said, hey, I think that attorney was negligent. I want you to sue him for damages. We somehow managed to delay the matter and put client off and so on, and we made it go away. Well, these days, attorneys are fair game. Attorneys get sued all the time. Now, if you gave an opinion, an urgent opinion, and the deal goes wrong, they might decide to sue you. So, take my advice. Give the opinion. Tell client, listen, I'll do the best I can in the time you've given me. I base my opinion on these limited facts, and I've not had enough time to research, but here is what I think, and this is what I recommend. When client goes off, you immediately write a short memorandum and you send that to client. Clients like it, number one. And number two, if things go wrong, you covered, okay? So, why do people want opinions? My view is, you'll hear this thing, they want an answer to a question. That's not what they want. When in practice, when a client comes to you for an opinion, they're looking for advice. That is why I say, give the answer to the question, then give the recommendation. That's advice. That's your role as a lawyer. You are also to present the opinion in a dispassionate and objective way. It is not your role to present an opinion that will please the client or advocate an outcome that your client desires. If on the facts as presented to you, your conclusion is that the course of action desired by your client is not permitted in law, then say so. Remember two things. Number one, you're an officer of the court. And number two, you are an independent practitioner. You are not your client's lackey. You are not to give opinions that are designed to make your client happy. Now, those of you who work in the corporate world or in government, I tell you, this happens in government all the time. The minister or the chief director, the one we call chief, the chief goes out there and makes a boo-boo. He buggers it up. He shoots his mouth off in public. The media get hold of it, and then there's a big problem. What they do, they come running to you, legal guy, and says, listen, give me an opinion that this is what I did. Give me an opinion that there's nothing wrong with it. So in other words, you're going to reverse engineer this thing. So you start, they give you the conclusion, and now you have to justify it in an opinion. Then they go to the media and say, listen, I wasn't reckless in saying that. I had an opinion. There it is. Now, if you think that doesn't happen a lot, think again. That does happen. That's where the lawyers get exploited, okay? So don't fall for that. You will damage your integrity. You'll damage your reputation. Okay? If it's wrong, it's wrong. You say it politely, it's wrong, okay? I've seen legal advisors in government being told, you are useless. You're telling me this is wrong. I'm telling you I did the right thing. You're telling me it's the wrong thing. If it's wrong, in your opinion, then stick to your guns, okay? That's being independent, and that is the ethically correct thing to say. You do two things when you write an opinion. You have to solve the problem. Then you have to communicate the answer. Now, that is not as easy as it sounds. First of all, to solve the problem, you have to show a process of reasoning. Now, one of the difficult things about being a judge is that in our system, the common law system, the adversarial common law system, judges are must give reasons for their decision. You know, I spent many years on the bench. Coming to a decision or a prima facie view is easy. I know what to do. I'll make an order. But now when you sit down and have to write your reasons, now it's not so easy. That is why when I train judges, I tell judges, never give the order and reserve your reasons for later. Bad judges do that. They'll say, I'll make the order now, I'll give you an order, but I'll reserve my reasons. You only do that in the urgent court, not otherwise. Because I've seen this happen all the time. Judge gave the order, now they're sitting to write the reasons and then discover, oops, I should never have given that order. Too late, okay? So you have to give reasons for your answer. Then you have to communicate your recommendation to client in a way that is practical and easy to comply with. So let's deal with the basic layout. Now, many of you probably heard of this already, the FIRAC method that is commonly used. FIRAC, it's an acronym. It stands for facts, issue, rule, argument, conclusion. Now, that is a logic that you've already seen. What are the facts? Facts come first. Now let's deal with the question or issues that emerge from those facts. Then let me take that question and contextualize it. What area of the law? That's the rule. Argument. I told you the next step in the logical sequence is to apply reason to your facts and the law. That's the argument. And then comes the conclusion. What this doesn't have is the last one, because in the past, you won't believe this, but there was a time when we wrote opinions where we just answered the question and left it at that, because that's our mandate. We've discharged it, fine. Not anymore. You don't stop at conclusion. Where the opinion calls for it, provide recommendations. Your client's not bound by it, but your client will find it helpful. I've often seen clients come with an opinion and say, okay, so I see what your answer is. So now what must we do? Tell me, what must we do? That's what the client will say. Don't waste time, put it in the recommendations. So the facts, it's what happened. What are the surrounding circumstances? What's the evidence? It's you asking all the what, where, when, why, and how questions. Issue, identify the issue or the question. What is the legal or factual question to be addressed? Now, that's the layout of your opinion. It goes like that. But let's just go back. Before you start with FIRAC, you must start your opinion with a brief introduction. And when I say brief introduction, I mean really brief. Introductions can be a waste of bloody time. 5 lines, okay? And please don't commence your introduction with, I have been asked. You know, it makes me sick. Every time I see someone's opinion, it starts with, I have been asked. Why do you have to say that? I mean, why would you write an opinion if no one asked you? Okay, so put in a short introduction about what the opinion is about. 5 lines. Then you go, issue, state the issues. Then state your answer to the issues. Then state your recommendation, and then go into the FIRAC method. Facts, issue, rule, identify the law, list the elements of each rule or the law. Where will you find those elements? You find it in the law reports. Now, if it's an area of the law you're not familiar with, then I suggest you read a good recent textbook on the subject. And it tells you what the law is. But textbooks are useful for one other thing. They give you references to the cases. And all you have to do is go to the law reports, find that case, bring it up on your screen, click on annotations, and in 2 steps, you found the most recent decision on the subject. You see, it's so easy, you save time. List relevant exceptions to the rule. You will have opinions. In fact, your opinion may be about the exception to the rule. List any relevant case names and statutes, if applicable. The next step is argument, which is justifying your view with reference to the facts and the law. You make a factual inference from the facts. You must say how you arrived there. You make a conclusion of law based on those facts. You have to state how you got there. And then conclusion. It means you must directly answer the question you are required to deal with. Then make recommendations, okay? That's the basic layout. Now I'm going to take you through each part and show you the best method of writing it. The FIRAC method is not to be followed slavishly. You can develop your own style, provided that you are able to answer the question and show your reasoning and come up with an answer. Why the FIRAC method is so popular and used as a standard is because it has the logical sequence to it. You don't want to start with the law and then deal with the facts, okay, and then talk about the issues. It's just too mixed up. It doesn't make sense. But if you have your own style of being able to provide an opinion where the reasons you give are logical and easy to follow, that's good enough for me. That's fine. When you write in your opinion, the FIRAC is just a useful guide, and there'll be four main parts to your opinion, okay? So basically, these are the four parts that you will have. So don't worry about slavishly following FIRAC. This is what you want. The first rule is always to commence the opinion by stating or setting out the facts as you have been instructed of them, or as from those instructions you have assumed them to be. You are not to undertake any legal research until you are familiar with those facts. I've stated that repeatedly. The facts are the most important. The next part, set out the question that your client has posed for you, or which you see arising and which you propose to answer. I told you, client will come up with a question, but client is a lay person. And I find that in many opinions, once you start looking at the question client put to you, when you start researching, you will find that, hold on, there are other issues here. There are other problems. We need more facts. I need to consult some more. Do that, okay? The third part is where you give reasoned answers to the question. And the fourth part, here you provide a summary statement of your conclusions, where a series of discrete questions have been asked, and you provide a precise, relevant answer. Then you provide suggestions or solutions for the way forward. Clients want that, okay? Now, I'm going to move on to research technique and analysis. This is extremely important for you. I will be dealing with factual analysis and legal analysis, okay? And then I'll weave in the write as you read technique. And I can assure you, if you follow this technique I'm going to show you now, at this point, you'll write your opinions very quickly. In fact, we train judges now to do that, to write as they read. In long cases, we train judges to, at the end of the day, to go inside Hold on, Betty, am I back? What's going on? Okay, are we back? Okay, let's start with Charlene's question. I've got some half an hour to deal with some questions, and then I'll stop for today. Okay? I think Charlene, what's your question? And I saw two more hands. No? Betty?
Judge, we don't see any questions on our
It
side.
says Charlene Schlebusch and 3 others have their hands up.
Yes, but they need to raise their questions in the chat function, sir.
Oh, okay. All right. Listen, Charlene and the others, just type out your question, send it to Betty, and I'll deal with it first thing when we get together tomorrow. Okay. Right. We'll stop for today. I'd like you to think about these techniques and commit yourself to using them. Tomorrow, we'll strengthen your understanding of this. What must be contained in the brief? Now, I can't read this. There's a question here. Okay, just send your questions through to Betty. She'll email them to me, and I'll deal with them tomorrow. All right, keep warm. I'll talk to you tomorrow. All right, Betty, I'm going to sign off now.
Thank you for your time, Judge.
Right. Okay. Right.